This is Alexandria Solar recording a media law video for Mass Communications 310 with Krystie Byrum. For the case that I chose the Pitt News versus Pappert case. So in 1996, PA legislature enacted an amendment to the state liquor code, properly known as Act 199, prohibiting any alcoholic beverages be advertised in virtually any media mass communications that affiliated with any educational institute. This affected Pitt News greatly at the time. An area restaurant, the Fuel and Fuddle, received a letter from the Bureau of Liquor Control Enforcement of the PA State Police. This letter caused a lot of people who advertised with Pitt News to stop advertising. The Pitt News then unsuccessfully sought to persuade the establishments to place ads that did not feature alcoholic beverages. So these people who advertised their alcoholic beverages could still advertise food, like featured food specials and other things that they sell, even though they sell alcohol, as long as the ad doesn't have alcohol in it. In April of 1999, the Pitt News filed complaints in the U.S. District Court for the Western District of Pennsylvania against state officials responsible for enforcement of the act. They alleged that it violated its constitutional rights of freedom of expression and freedom of the press and the equal protection of these laws. They moved for a preliminary injunction, and an evidentiary hearing was held. In July of 1999, the district denied the motion and held that Pitt News lacks standing. They could not assert First Amendment rights for their advertisers or their readers, and the paper had not itself suffered any injury. And they said that also it could still publish anything it wanted as long as they weren't getting paid for it. So the newspaper technically could advertise for free. So they could post about alcoholic beverages or basically anything they wanted as long as they weren't getting paid for the content. The TPNI panel decided that the case had not shown likelihood of succeeding the merits of its claim. The First Amendment does not protect a publication's rights to profitability. And although the enforcement of the act has had the result of driving away certain closely regulated businesses who previously advertised in the Pitt News, this does not in itself amount to a violation of the Pitt News First Amendment right. The final ruling concluded that Section 498 is unconstitutional as applied to the Pitt News. This is why it has to do with communications. The law that was enacted represents an impermissible restriction on commercial speech. The law is presumptively unconstitutional because it targets a narrow segment of the media, and the Commonwealth has not overcome this presumption. Some of the key conclusions are that the purpose of the section of 498 is to discourage a form of speech that the Commonwealth regards as unlawful. If the government suppressed all disfavorable speech by preventing speakers from being paid, there wouldn't be much left of the First Amendment. Thank you.